A federal appeals court has allowed the Trump administration to resume expedited deportations nationwide, and the ruling is already reshaping how immigration enforcement works across the entire country. In a 2-1 vote, a 3-judge panel of the U.S. Court of Appeals for the District of Columbia Circuit ruled Tuesday that the president can expand a fast-track deportation process, one that was previously used almost exclusively near the southern border, to arrests made anywhere in the United States. So what exactly is expedited removal? It's a procedure that allows immigration officials to deport people who have been in the country for less than 2 years without any hearing in immigration court. Historically, it applied to undocumented migrants caught close to the border shortly after crossing. But when President Trump took office in January 2025, he directed Immigration and Customs Enforcement to apply it far more broadly to migrants encountered anywhere in the country's interior who couldn't immediately produce proof they'd been here longer than 2 years. A lower court had blocked that expanded policy last August, ruling that it most likely violated due process rights and risked wrongful deportations. Tuesday's appeals court decision revives it. The majority opinion was written by Judge Justin Walker, a Trump appointee, and joined by Judge Naomi Rao, also a Trump appointee. Judge Walker wrote that Congress had delegated to the executive branch the authority to decide which migrants to designate for expedited removal, and that the Trump administration was simply using that authority to its fullest extent. He also wrote that the government is not legally required to inform those arrested about how they might avoid expedited removal, specifically, that they could challenge it by proving they'd lived here for at least 2 years. As long as migrants are given what he called a brief but reasonable opportunity to provide documentation, the legal requirements are met. Judge Robert Wilkins, an Obama appointee, dissented sharply. He pointed out that the Department of Homeland Security had not disputed that, under this policy, it had already deported some individuals who had actually been in the country longer than 2 years. He stressed that immigration officers were not required to ask people how long they'd been in the country, or to tell them they had the right to challenge their removal. As he put it, a procedure that can result in deportation without even asking someone how long they've lived here might be adequate at the border, but is, quote, woefully inadequate for people encountered deep inside the country. Immigration advocates have raised similar alarms. Doris Meissner, a former top immigration official under both Clinton and Reagan and now a director at the Migration Policy Institute, said the ruling gives the federal government what she called a broad sweeping power that could incite fear across immigrant communities. She raised a practical concern that many people may not carry documentation proving how long they've been in the country, and noted it's still unclear what proof would even be sufficient. The lawsuit was brought by Make the Road New York, a nonprofit immigrant advocacy group. Their lawyer, Anand Balakrishnan, had argued that the expanded policy left virtually everyone without full legal status, including people who've lived in the United States for decades and have deep family and community ties, vulnerable to being placed on a fast track for deportation with almost no meaningful oversight. He noted that the decision of whether someone gets a chance to make their case falls largely to the discretion of the individual arresting officer. The Department of Homeland Security celebrated the ruling. Its general counsel said the department had long arbitrarily limited expedited removal even though the law allowed a broader application, and said the appeals court had vindicated the administration's approach. It's worth noting that the case could continue. The nonprofit that brought the lawsuit has not yet commented on next steps, and the dissenting opinion gives future courts a roadmap for challenging the ruling. This is a story about the boundaries of executive power over immigration, and about what due process actually means in practice for millions of people living in the United States without full legal status, and we'll be watching closely to see where it goes next.